By 9 a.m., two of the expelled NRM MPs were at the Supreme Court in Kololo, seeking an injunction against the Constitutional Court ruling that ordered them out of Parliament. But the case took a dramatic turn after the lead counsel of the expelled MPs, Professor George Kanyeihamba, showed up in court only to find that his application was not listed for hearing. The mix-up sparked off a quarrel with his clients. Immediately after the hearing began, Professor George Kanyeihamba raised concerns about the tampering of his application and threats to his life. He then stormed out of court in protest.
No, ever since then, ever since the judgment, first of all, my lawyers ran away. I called them, they don't answer. When I use other phones and they notice my voice, they switch off. They conspired to remove me from the leadership.
The fact that we have several applications, we have about 4 of them in this court. And what Honorable Justice retired Kanyeihamba filed was application number 2, which had several issues that we hadn't yet agreed upon. But this one was immediate. The interim could not wait.
Prefer that it's I and Peter Walubiri. And then that's the, because they could have as well have said Alaka be out and Kanyeihamba be in. They're the ones who see the value in us, so it's not my problem. It's really for the clients. And of course, you have also seen his conduct in the Constitutional Court when he said that the judgments were irregular. You don't do that to courts.
Despite Kanyeihamba's protest, the bench of 5 Supreme Court judges, led by Justice Benjamin Odoki, continued hearing the application in a fully packed courtroom. The MPs are seeking an interim order to restrain the Speaker of Parliament, a deputy, and the Electoral Commission from implementing the Constitutional Court order. Last week, the Constitutional Court ordered the 4 expelled MPs to vacate their seats and directed the Electoral Commission to organize fresh elections. The lawyers representing the state argued that the orders of the Constitutional Court had already been implemented, thus no need of the appellant court to issue other orders staying them. They further argued that the applicants failed to prove to court that their only source of income was from Parliament, thus they were going to suffer unrepairable losses in case they are ejected.
Because surely if that is the only source of income they have, then it means that they are a danger to society. They're a danger to society. It means they are amenable to many temptations.
We're just telling the Supreme Court that, look, we have put a notice of appeal, and these issues we are raising are of great national importance to our country. If a party member is chased away by the organs, what do? Do you allow them just to live like that? Won't it affect everybody in that parliament?
Our argument is that the application has been overtaken by events and there is nothing to stay. The process should continue and people should not remain unrepresented.
The MP's lead counsel says if the status quo remains, then the MP's constituents will not be represented in Parliament until the appeal is disposed of.
At the moment, they do not represent their constituents in a manner prescribed by law. Because they were elected on an NRM ticket, NRM expelled them, and so now they cannot claim to be representing their constituents in that way.
Court adjourned the case to Thursday the 6th of this month. Meanwhile, the main application is set to be heard on the 28th of March. Sudhir Byaruhanga, NTV.